I believe we have our. Let's call the case of Marks versus Sunny Rooftop Bar. I'm Judge Jackson Lucky. Everybody who is not performing at this time should have their audio and video off. It looks like everybody has their video off. Thank you very much. And that should remain off until the trial ends. Also, for a better viewing experience, you may want to hide non-video participants. Those of you who have watched prior rounds probably already know how to do this, but if you don't, go to anybody's image, and there should be 3 dots as you mouse over, and click on that, click hide non-video participants, and that will hide, for the most part, just the bare names without any image. And we'll start with appearances of counsel. Why don't we start with the plaintiff's counsel?
Yes, Your Honor. Good afternoon, Your Honor, members of the jury. My name is James Staub, and today I'm joined by my co-counsel, Thomas Staub.
Good afternoon, Your Honor.
Afternoon.
And together we represent the plaintiff, Ethel Marks, in this case. And Your Honor,
Yes, go ahead, Mr. Staub.
After the defense has stated any appearances, the plaintiff, we do have a few preliminary matters we'd like to address.
All right, Mr. Staub, remind me if I forget, and why don't we get appearances for plaintiff? I'm sorry, for defendant.
Yes, Your Honor. Good afternoon. My name is Henry Long, and I'd like to apologize in advance for my voice. I'm getting over a cold right now. And today I represent Sunny's Rooftop Bar, along with my co-counsel, Mr. Muthu Vignesh Meenakshi Sundaram.
Good afternoon, Your Honor.
Good afternoon.
And today we are joined by the owner of Sunny's Rooftop Bar, Mr. Sunny Mehta.
Afternoon, Mr. Mehta. All right, does that conclude appearances for defense?
Yes, it does. We're ready to move into pretrial matters.
Outstanding. And Mr. Staub, you said you had a couple?
Yes, Your Honor. First, we'd like your preference on showing exhibits not yet in evidence on the screen.
We'll, in the interest of time, we'll consider any exhibits as they're first shown to a witness to be constructively outside the presence of the jury. Once I say that that exhibit can be moved into evidence, you can publish it to the jury without asking permission. So once I say it's admitted, just we'll consider it constructively displayed to the jury.
Yes, Your Honor. And lastly, we'd like to mark stipulation 13, which states, at all times relevant, Frankfurt Johnson and Sunny Mehta were acting on behalf of the defendant.
So stipulated, Mr. Long?
Yes, Your Honor. For our pretrial matters, we'd like to first ask you a few questions since this is our first time in your virtual courtroom. Additionally, with exhibits and demonstratives, would you like us to ask permission before putting those up on the screen, or just announce what we're doing?
I'm glad you brought that up. If you've had a chance to review demonstratives with each other, then unless there's an objection, which I would expect to hear now, I will just allow you to display them to the jury. If you haven't had a chance to exchange them, then what we'll do is treat it as we would other exhibits, go constructively outside the presence of the jury, have you review it with opposing counsel off the clock, and then we will resume in front of the jury after counsel have had a chance to review each other's demonstratives.
Yes, Your Honor. Seeing as we have not had a forum to see each other's demonstratives, we'll assume that those are outside of the presence of the jury until approved by opposing counsel.
Outstanding.
Now, as for exhibits, would you like us to still ask permission before putting those up on the screen, or just announce what we're doing?
No, just say what you're doing for the record. We'll presume that it's outside the presence of the jury until it's been properly authenticated.
Yes, Your Honor. And lastly, seeing as there's limited time in today's trial, we as the defense would like to propose a stipulation to opposing counsel, and my co-counsel would put that up on the screen.
And Mr. Staub, did you want to be heard on the proposed step?
Your Honor, we have no objection.
All right, we'll show that the parties have entered into stipulations 13 and 25, and I will so instruct the jury.
With that, the defense is ready to proceed to opening statements, excuse me.
No problem, Mr. Long. If that's the only thing that you misspeak today, you'll be ahead of me. All right, then we've taken care of our preliminaries. Why don't we get to opening statements and starting with Mr. Staub.
Yes, Your Honor. May it please the court. On March 24th, 2019, a 19-year-old woman named Jessica Marks died in a car crash after leaving a bar for one reason. Because the defendants, the people working at the bar she just left, had a duty to protect her, to stop supplying her with alcohol when she was already drunk. But you'll hear they didn't even try to fulfill it. They could have stopped her when she walked in already drunk. They could have stopped her any of the 10 times they visited her table that night. They could have stopped her at any point in the evening when she showed signs of obvious intoxication, but they didn't even try. So, as the plaintiff, we've brought a claim of wrongful death against Sonny's Rooftop Bar, the defendant. And because it's undisputed Miss Marks was underage, she was only 19 years old, the only thing we have to prove to you today was that the servers at that bar saw the signs of her intoxication, continued to serve her anyway, and that caused her death. We'll meet our burden today because we'll prove that even though she showed those signs of intoxication, they didn't even try to keep her from drinking more. First, you'll hear about those signs of intoxication. You'll learn about all the drinks she had that night. Wine, beer, shots, 3 hard seltzers. You'll learn that at the time of her death, minutes after leaving that bar, her blood alcohol concentration, her BAC, was found to be 0.16%. That's twice the legal limit for an adult in the state of California. 16 times the legal limit for someone of Jessica's age. But you won't just have to hear about it. You'll be able to see for yourselves how Jessica was acting. You'll see a video taken almost an hour before she left that bar that'll show just how obvious those signs of intoxication were. And you'll learn that the defense's witness, the owner of that bar, Sonny Mehta, saw those signs of intoxication and said they should try to stop serving her. But members of the jury, they never tried to stop her. You'll hear they continued taking her orders, continued making drinks, brought round after round to her table from 9 p.m. to near midnight. You see, Sonny's bar had a responsibility to protect an obviously intoxicated minor, and they didn't even try. So at the end of this trial, we'll ask you to hold Sonny's Rooftop Bar liable for the death of Jessica Marks. Thank you.
Thank you, Mr. Staub. Mr. Long, would you like to make your opening at this time or reserve?
I'd like to make it at this time, Your Honor. Just a moment while I get ready.
Of course.
May I proceed?
Yes.
Members of the jury, my client couldn't stop what they didn't see. On March 24th, 2019, Jessica Marks and Morgan Levin went out for a big night on the town. After meeting at Miss Marks's Airbnb and having a few drinks, The two decide to go over to Sonny's rooftop bar, just outside of LA. You'll hear that throughout the night, Miss Marks seemed fine after a few rounds of drinks. She'd order each drink clearly and coherently and move about without any problem. She gave the bartenders no reason to believe that she'd had too much to drink. So they kept serving her. They couldn't stop what they didn't see. Now today, the plaintiff is accusing my client of wrongful death. And when they did that, they assumed a burden, meaning that they have to prove two things to you more likely than not. First, that my client knew that Miss Marks was intoxicated when they served her. And second, that serving was a substantial factor in her death. Now, the key word from that burden is the word knew. Mr. Staub can't just tell you that the Miss Marks had been drinking to win his case. Now, he has to prove that my client knew that Miss Marks was intoxicated and then served her more to drink. So listen closely today, because if Mr. Staub brings forth evidence about how much Miss Marks had to drink, that doesn't meet their burden. If Mr. Staub tells you about what Miss Marks's BAC was that night, that doesn't meet their burden. If Mr. Staub tells you how Miss Marks was acting when the servers weren't around, that doesn't meet their burden. Because none of that tells you whether my client knew that Miss Marks was intoxicated before they served her. They couldn't stop what they didn't see. Now today, you're going to hear from Sonny Mehta, the owner of Sonny's Rooftop Bar, a family business operating just outside of LA. Mr. Mehta will tell you about his experience as a bartender and the signs he typically looks for when cutting someone off. He'll tell you that Miss Marks exhibited none of those signs. In fact, you'll hear that Miss Marks was perfectly sober whenever my client was around. He couldn't stop what he didn't see. Members of the jury, tragedies like this are hard to talk about. But today's case is going to require you to grapple with something difficult. The role that Ms. Marks played in all of this. We're going to ask you to consider whose actions caused her death. Was it the one who got in her car that night, knowing full well she was in no condition to drive? Or the bar that served a seemingly coherent customer the drinks that she asked for? Members of the jury, my client couldn't stop what they didn't see. That's why I'm going to come before you at the end of today's trial and ask you to find my client, Sonny's Rooftop Bar, not liable. Thank you.
Thank you, Mr. Long. And I'll remind everybody to switch to gallery view for the presentation of evidence, which is a win for me because I usually forget to do that. All right, and the plaintiff ready with their first witness?
Yes, Your Honor. The plaintiff calls Morgan Levin. May I proceed?
Yes.
Good afternoon, Mr. Levin. What do you do for a living?
Good afternoon, sir. I'm a college student. I'm a junior at UCLA.
Now, how are you involved in today's case, Mr. Levin?
Well, I was with Jessica Marks the day that she died.
How did you know Jessica Marks?
Jess was my best friend all throughout middle and high school. We grew up together. We did everything together and, well, she was my best friend.
Well, you said you were with Miss Marks the night she died. Do you remember where you were?
Yeah, Jess and I went to Sonny's Rooftop Bar in Malibu.
And about what time would you say you arrived?
I would say it was around 9 p.m. that night.
So I need to ask you about the details of that night, Mr. Levin. When you first arrived at the bar, could you describe Jessica's behavior?
Yeah, Jessica was starting to appear drunk. She had bloodshot eyes, smelled of alcohol, and she was talking really loud for Jessica. She was slurring her words.
Well, when you got inside, did the servers introduce themselves to you?
They did. Sonny Mehta, the bar owner, was the one that served us, and Frankfurt Johnson was his bartender. There were only 2 employees that night.
So how many times would you say you interacted with Sonny in particular?
I'd say around 8 to 10 times. He was our server the whole night, and yeah, I'd say around 10 times.
Well, would you recognize a copy of your receipt from that night?
I would, sir.
Your Honor, I'm showing what's been pre-marked as Exhibit 17. Mr. Levin, is this a fair and accurate copy of your receipt?
It looks like it. That's my signature right at the bottom.
Your Honor, the plaintiff offers Exhibit 17 into evidence.
Any objection?
No objection, Your Honor.
17's admitted.
So, Mr. Levin, which of these drinks on this receipt did you drink?
Well, I'm not much of a drinker myself, so I only had 3 drinks. I think I had 1 glass of wine from that decoy red blend, 1 beer, and 1 shot.
And from what you saw on March 24th, which of these drinks did Jessica Marks have?
Well, Jessica had a lot more than me. She had 2 or 3 glasses of the wine, 3 White Claw hard seltzers, a beer, and a shot. Sir, she had a lot of wine to drink.
So, as the night went on, and Sonny was bringing all that alcohol to your table, how would you say Jessica was acting?
All over the course of the night, Jess seemed to get drunker and drunker. She got even louder, her eyes started watering, and she continued to slur her words. Now, at one point, she was stumbling so much that she almost fell down the stairs.
You said she almost fell down the stairs. Do you remember what time that was?
Yes, I believe it was around 10 p.m., towards the beginning of the night.
Was there anyone else around when she almost fell down the stairs?
There was. Sonny Mehta, the bar owner, was standing right there, and so was the bartender, Frankfurt. In fact, Jess even stumbled right into Sonny Mehta.
Did Sonny say anything when Jess stumbled right into him?
Yes, he did. Sonny said, "Whoa, Frankfurt, we might need to cut this one off."
When Sonny said we might need to cut this one off, did he stop serving Jessica Marks alcohol?
No, sir. Sonny kept serving Jessica alcohol for the rest of the night.
Well, let's move forward to later that night. Your Honor, I'm showing what's been pre-marked as Exhibit 10. Mr. Levin, do you recognize the image on the screen?
Yeah, I do. It looks like the beginning of a video that I took of Jessica that night.
Do you remember what time you took that video?
Well, it was posted at 11:11, so I assume I took it at around 11 p.m.
And have you seen this video all the way through?
I have.
Mr. Levin, does Exhibit 10 accurately depict how Jessica Marks was acting on the evening of March 24th?
Definitely.
Your Honor, the plaintiff offers Exhibit 10 into evidence.
Any objection?
Yes, Your Honor. I object under the grounds of substantially more prejudicial than probative.
All right, Mr. Long, why don't I hear from you first?
Yes, Your Honor. Today, Mr. Staub has the burden of proving that my client knew that Ms. Marks was intoxicated. And this video was taken when my client wasn't present. Therefore, showing how Ms. Marks was acting when my client wasn't present has substantial ability to confuse the jury as to what's going on, because the video was taken when my client wasn't present, and therefore it doesn't show whether my client knew that Ms. Marks was intoxicated when they served her.
Mr. Staub.
Your Honor, under Rule 403, opposing counsel has to show how this is substantially more prejudicial than it is probative. And Your Honor, we've already established that its probative value is more than it's prejudicial. You heard today from Mr. Levin that the way Miss Marks was acting in this video, regardless of whether the employees were there, was how she was acting the rest of the night. It goes to the weight of his testimony that when she was acting drunk in this video, she was acting drunk when the employees were there as well.
And Mr. Long, it's your objection. Anything else before I rule? I'll give you the last word.
Yes, Your Honor. I'll just say that when this video was taken, the fact that my client wasn't present, that is substantially more prejudicial than probative, because it has the ability to confuse the jury as to whether my client saw this video.
All right, thank you both very much. Under the substantially more prejudicial than probative standard, I think that because this was maybe not contemporaneous with the defendant's viewing of the decedent, but at least close in time, that it does have high probative value. And I do not find that the prejudice that would result substantially outweighs it. The objection is overruled. Exhibit 10 is admitted.
All right, so let's play this video.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
So, Mr. Levin, we've talked about Jessica stumbling down the stairs. We talked about how she was acting in that video. I have to ask, did Sonny ever say anything to you about Jessica's behavior?
Yes, he did. In fact, he even pointed right at Jessica and said, I hope this one's not driving home.
When Sonny said, I hope this one's not driving home, did he stop serving Jessica alcohol?
He didn't. Just kept on getting served alcohol, and not until closing time, when around 11 p.m. or 11:45 p.m.
So what time did you leave Sonny's bar?
Close to closing time. It was 11:45.
I know this may be difficult for you, but what happened after you left that bar?
Well, my Uber and Jessica's car, we went out on the highway. Almost as soon as we turned onto it, just 1,000 feet from the bar. Well, that's when Jessica's car went across the divide. And, sir, that's when she died.
Thank you, Mr. Levin. Your Honor, I have no further questions.
Cross-examination?
Yes, Your Honor. Just a moment while I get ready.
Of course.
May I, just a moment while my camera focuses. There we go, Your Honor. May I proceed?
Yes.
Mr. Levin, Ethel Marks is the plaintiff in today's case, right?
That's correct. She is. She's Jess's mother.
And Jessica is your best friend.
That's right. She was my best friend.
And at one point, your best friend's mom threatened to sue you over Miss Marks's death.
Well, that's right, sir. I mean, if her death hit me, well, her death hit me very, very hard, and I can't imagine what Jess's own mother would take that.
But she didn't end up suing you, did she?
No, she didn't.
Instead, you're here testifying on her behalf.
Yes, that's correct.
In fact, before you were deposed, you talked to Ms. Marks's lawyers for a few hours.
That's right, but it was over a year ago, so I don't 100% remember everything that was said.
When you also talked to Mr. Staub before you prepared for trial today.
That's correct.
And you'd agree that your recollection of the night of March 24th, 2019 is important for the members of the jury to know.
I mean, yes, I was the eyewitness.
Let's talk about what might impact your recollection of the events of March 24th, 2019. Now, you talked to the police right after Miss Marks died. Is that right?
Yes, I believe it was Officer Sammy Gaskins. That's right.
And you told the police that you had nothing to drink.
Yeah, well, my best friend had just died. I was in the stress of the moment. I was scared, sir.
But then you changed your story.
Well, as I said, I was scared, and yes, I was drinking that night. But my best friend had just died completely out of the expected, and I was just very scared, sir.
Well, you then told the police that you had 3 drinks that night. Is that right?
Yes, that's correct. I testified to that in direct.
You told them that you had a glass of wine,
That's right.
a beer,
Yes, I can't remember exactly which beer it was. It was either the IPA can or the draft.
and a shot for your last drink.
I believe that's correct, sir. I had a shot.
Well, Your Honor, at this time, we'd like to bring a portion of Stevie Redger's deposition up onto the screen, which is admissible under Rule 804B1. Does opposing counsel have any objection to us reading this onto the record?
Your Honor, we have no objection to these specific lines being read into the record, but not to the admission of Stevie Reger's deposition as a whole. We would have objections to that.
And at this point, Mr. Long, you're just proposing to read these lines 11 through 16 into the record?
Yes, Your Honor, just these lines at this time.
Go ahead, sir.
Tell me every drink you saw her have.
She had a couple White Claws. She had a beer or two. There was a bottle of wine on the table. I think she had a couple glasses of red wine.
And Morgan Levin?
Same plus maybe more.
So you claim that you only had 3 drinks that night, and none of those 3 drinks included a rum and Coke. Is that right?
Excuse me, Your Honor.
Mr. Long, there was an objection. Mr. Staub.
Yes, Your Honor, I'd object misleading the jury under Rule 403 because as opposing counsel was reading this deposition, he replaced the term her friend with Morgan Levin. There's a lack of foundation as to that being Morgan Levin, and as of right now, it's misleading the jury as to what this deposition says.
Mr. Long?
Your Honor, if you read through that deposition, you know that Jessica Marks was referred to as the one having all of those drinks. And her friend, as Mr. Levin testified today, he was the friend that was with her at the bar that night. So if you want, we can show you some lines that say who was Jessica and who was her friend. But if you look at the deposition, when it says she, it refers to Jessica. And when it says her friend, it refers to Mr. Levin.
All right. I understand the argument, Mr. Long, but the hearsay exception that allows former testimony does not, to my knowledge, allow paraphrasing. It allows reading in the deposition transcript. And so I'm going to sustain the objection, instruct the jury that the transcript, as shown, is the former testimony of the witness. And if you wish to lay further foundation for that inference to be drawn, I'm happy to let you do so. I'm not saying that you're wrong on what inference should be drawn, but I'm saying that's an inference and it's not in the deposition transcript as read.
Yes, sir. Yes, Your Honor. Moving forward, we'll read the deposition as written. Now, Mr. Levin, you claim you had 3 drinks that night. None of those 3
Yes.
drinks was a Jack and Coke, was it?
Well, I didn't have a Jack and Coke. That's correct. I did not. I had 3 drinks.
Well, now let's read another portion of Stevie Redger's deposition. And her friend?
The friend had some Jack and Cokes.
Now, you claim, Mr. Levin, that you weren't drunk that night, were you?
No, I wasn't. I only had 3 drinks, sir.
So if you were drunk, you certainly wouldn't have trouble getting up and walking around.
I mean, I was a bit tipsy, a bit buzzed, but I was not certainly as seemingly drunk as Jessica Marks.
Well, you certainly wouldn't have had trouble walking in a straight line.
Well, I was a bit buzzed. I mean, I did have 3 drinks. I wouldn't say I was visibly intoxicated like that, but I mean, if you're buzzed, you do show certain small symptoms. I would say Jessica was much more intoxicated than me, though.
Well, let's look at another portion of Stevie Redger's deposition. How was she walking?
Fine, I guess. I don't really remember. I just remember her friend was wobbling like she'd been in the ring with a boxer.
Now, Mr. Levin, let's talk a little bit about Jessica's experience with drinking. Now, Jessica started drinking in high school, is that right?
I believe that's correct, yes.
And in high school, she'd have drinks every weekend at parties.
Yeah, that's accurate.
Objection, Your Honor, inadmissible character evidence under Rule 404.
Mr. Staub, I'll hear from you first, and then Mr. Long.
Your Honor, showing that Jessica Marks had drinks in college only goes to her conduct and conformity on the night of March 24th. That because she was acting drunk when she was in high school and in college before, she had gotten used to drinking and was drinking on the night of March 24th. Your Honor, it's inadmissible according to Rule 404.
Mr. Long.
Your Honor, we're not using the evidence that Miss Marks drank in high school and college as propensity evidence to say it was more likely that she was drinking a lot on the night of March 24th. Rather, we're using the evidence that she drank in high school and college to show that Miss Marks had built up a tolerance for alcohol and therefore knew how to hold her drinks. So we're using it for knowledge, which is admissible under Rule 404B.
Mr. Staub, your objection, I'll give you the last word.
Your Honor, if they're only offering it to show the knowledge of her tolerance, we have no objection, but we'd like a limiting instruction to the jury to show that they're not using this evidence for conduct and conformity.
All right, I'll instruct the jury accordingly. With that, the objection is overruled, subject to the limiting instruction. And Mr. Long, you can inquire.
Yes, Your Honor. Now, Jessica was drinking even more at college. Is that right, Mr. Levin?
That's right, but in high school, she only had maybe 1, 2 drinks. At Sonny's rooftop bar, she had a lot more than that.
Well, Jessica also had some experience with drinking and driving. Is that right?
I guess you could say that, but again, she only had 1 or 2 drinks while she was in high school and the week leading up. At Sonny's rooftop bar, she had many more drinks than that because they did not cut her off.
Well, in fact, when she was at Sonny's rooftop bar, she told you that she'd gotten pretty good at driving after a big night.
I mean, yeah, that's correct. She did tell me that.
Well, now let's talk about some of the things that you saw that night. Now, you claimed on direct examination that you just saw Miss Marks getting drunker and drunker. Is that right?
That sounds accurate. She was getting drunker and drunker.
But Mr. Levin, you can't point to a specific instance where she had red eyes in front of the bartenders. Is that right?
I mean, sir, it was over 2 years ago to this point. I can't remember every specific instance that happened, but I can tell you that she did have red eyes. She did have red eyes. I just can't remember maybe a specific time. But again, it was 2 years ago.
So that's a yes to my question that you can't point to a specific instance.
Yes, that's correct. Although again, it was a long time ago.
You can't point to a specific instance where she had flushed cheeks in front of the defendant.
No.
And I have a note in the chat that says time has expired. And I have a note that there's a discrepancy. So why don't we stop time for a moment and I'll hear from both sides. Why don't we hear from the plaintiff first?
Yes, Your Honor. Opposing counsel, the defense has run out of time for cross-examination. Yes. Your Honor, I have 4 separate timers. I have 2 for the plaintiff and 2 for the defense. One that has how much time they have and how much time they've used. Now, those timers, both of them have lined up and said that the defense has run out of time for cross-examination.
All right, and let's hear from defense.
Yes, Your Honor. First, I'd like to ask if you can hear me all right. Okay. I just have the one timer. I don't have 4. I'm not plaintiff counsel over here. That's pretty cool. And I've been writing down the times throughout the trial on a piece of paper here, and I've got my one timer. Now for cross-examination, defense counsel has 7 minutes total. I have him at 6:30. He's showing 30 seconds remaining.
And was there any stoppage time for objections or anything like that from either timer?
Yes, Your
Yes,
Honor,
Your Honor. I
stopped
paused
time
during
for
objections.
objections.
All right. So we have one side saying that there are 7 minutes and there's one side saying that only 6.5 minutes have been used. All right, I'm going to go ahead and give the additional 30 seconds. I don't think that it's that huge a discrepancy. I'll figure that both of you can keep track of the remaining 30 seconds. And Mr. Long, you can continue, sir.
Mr. Levin, you also can't point to a specific instance where Miss Marks slurred her words in front of the bartender.
That's correct. Not one specific instance, but again, it was over 2 years ago. I don't remember every specific instance. All I know is that it happened for sure.
Thank you, Mr. Levin. No further questions, Your Honor.
Thank you, Mr. Long. Any redirect, Mr. Staub?
Sorry about the delay, Your Honor. Yes, I do have redirect examination.
Anytime you're ready.
Yes, Your Honor. Now, opposing counsel asked you about drinks that Miss Marks had in high school and college. About how many drinks would you say she would have on those occasions?
Only around 1 to 2, sir. It wasn't very many.
And how many drinks did she have on March 24th?
A lot more than that. I would say at least 5, if not more drinks. There was a big difference between before and at Sunny's rooftop bar.
Thank you, Mr. Levin. Your Honor, I have no further questions.
Mr. Long, recross?
No recross, Your Honor.
Thank you, Mr. Levin. You can step down.
And Your Honor, before we rest our case, we'd like to read into the record a portion of an exhibit that's been pre-admitted.
Go ahead.
We'd like to display exhibits 22 and read the specific boxes on screen. Specifically, the subject is a normally developed 19-year-old white female. And down at the bottom box, the blood drawn at the scene of an accident contains 0.16 grams per 100 milliliter of blood, BAC.
And Mr. Long, you have agreed that this exhibit is pre-admitted?
Yes, Your Honor. The exhibit has been pre-admitted.
All right, then we will allow the jury to view the exhibit and the particular excerpts that Mr. Staub is showing.
And with that, Your Honor, the plaintiff rests.
Thank you, Mr. Staub. And then let's get to defense witnesses. Mr. Long.
Yes, Your Honor. At this time, we call Sunny Mehta to the stand.
Mr. Long, your witness.
May I proceed?
Yes.
Yes, Your Honor. Please introduce yourself to the members of the jury.
Good afternoon, everyone. My name is Sunny Mehta. That is Mehta.
What do you do for a living, Mr. Mehta?
For a while, I owned a bar, but I am now looking for my next big business venture.
Well, what was the name of the bar you owned?
It was called Sunny's Rooftop Bar.
And what were some of your responsibilities when running that bar?
Oh, well, I was the owner, so, I would check the payrolls, I would schedule everyone for time, and, I would make sure everyone was up to date on like certifications for being able to serve alcohol. But I would also do stuff like serve the alcohol myself or take orders.
Well, let's talk about a specific time you were taking orders. Could you tell us how the night of March 24th, 2019 began for you?
Yeah, sure. It was, it was a regular, not very busy night. It was just me and Frankfurt Johnson working that night. And we were just doing our normal things.
Now, I'd like to talk to you about two of your patrons that day. Do you remember Jessica Marks and Morgan Levin?
Yes, I do.
When did you first see them?
It was around 9 p.m.
And how did they look when you first saw them?
I mean, they hadn't ordered anything yet. They looked completely sober to me.
Well, let's talk a little bit more about how you might determine that. How do you typically tell if someone's had too much to drink?
Well, I and all my employees had to take this course, and it kind of gave us these signs to look out for if someone was obviously intoxicated and when knowing when to stop serving them alcohol.
Well, could you tell us what some of those signs are?
Yeah, sure. It's stuff like red eyes, a flushed face, smelling like alcohol, if they ever stumble or lose their balance, if they have trouble getting out of their chair or standing up, if they ever show any lack of coordination, anything like that, or if maybe they're talking all slurry, or if, they're really, really loud, stuff like that.
Well, now I'd like to talk to you about some of the things that Mr. Levin said on direct. Do you remember what Mr. Levin said? How many drinks Mr. Levin said they had that night?
Yeah, he said he only had 3.
Is that how you remember the night of March 24th?
Well, I couldn't tell you exactly how many drinks everyone had, but I'm aware that table altogether ordered around 12 drinks. And how I remember it is they were both seemingly ordering very similar amounts. So I would ping Mr. Levin at more like 5 or 6 drinks.
And Mr. Mehta also, do you remember what Mr. Mehta said happened on the stairs?
Oh yeah, he gave some story about Miss Marks almost falling and hitting into me or something like that. That never happened.
Well, now let's talk about what did happen. Do you remember about how many drinks he served Miss Marks that night?
Again, I couldn't tell you an exact number on what Miss Marks was ordered, but I would again say around 5 or 6.
Does the amount of drinks that someone has tell you whether they're going to be obviously intoxicated?
No, not at all. People handle their alcohol. They take it completely differently. How much they have doesn't tell me anything.
Could you tell us a little bit more about what you mean by that?
Yeah, sure. So if someone takes their alcohol really well, then they may have more drinks than someone who doesn't take it well and not show a single sign of intoxication. For example, that night, Miss Marks seemed to take her alcohol very well. I didn't notice any symptoms from her. But on the other hand, Mr. Levin did not seem to take his alcohol all that well because he wasn't looking too great.
Well, tell me a little bit more about Mr. Levin. How could you tell he wasn't looking so great?
Yeah, sure. There were times, this was towards the end. He wasn't making much sense. He was struggling to walk right. especially when they were leaving, he just overall was showing some of those symptoms of intoxication as he was leaving.
Now, what about Miss Marks? Was Miss Marks showing any of those signs of intoxication?
No, not at all. I never saw her showing any of those signs.
Well, let's bring up some of those symptoms of intoxication you talked about earlier onto the screen. Now, Your Honor, permission to pause the time so opposing counsel can approve use of this demonstrative.
Sure, we'll pause the time while opposing counsel reviews the demo. And then Mr. Staub, let us know if you're ready and if you have an objection.
No objection, Your Honor.
All right, we'll start the clock and you may proceed, Mr. Long.
Yes, Your Honor. Mr. Mehta, did Jessica Marks have red or watery eyes?
Not that I saw.
Were her cheeks flushed that night?
Certainly didn't appear so.
Did she smell like alcohol?
I never smelled it.
Did she ever lose her balance?
Not in front of me, at least.
Did she ever have trouble standing?
No.
What about poor hand-eye coordination? Did you see any of that?
I did not.
Did she ever slur her words?
I never heard that.
Was she ever talking more loud than usual?
No.
Mr. Mehta, did Miss Marks ever appear drunk in front of you on the night of March 24th, 2019?
No, she never did.
Thank you, Mr. Mehta. No further questions, Your Honor.
Mr. Staub.
Yes, Your Honor. Good afternoon, Mr. Mehta.
Good afternoon.
Now I want to start by talking about something you told us on direct examination. You told us today that you've been trained to identify signs of intoxication.
Yeah, me and all my employees. There's a course that we have to take. I believe it's every 3 years. And yes, it provides that training.
You and every employee is required to take that course you're telling us about.
That is correct.
And you told us on direct examination that your part of your job was to make sure everyone was up to date on their certifications.
Yeah, they had to take it every 3 years. So, I would go up to them and I would ask them, hey, are you up to date on your certification? And if they weren't, they would be. And if they said yes, they're good to go.
Well, you never verified with the course that they completed it. Did you?
No, I made sure that I hired trustworthy people to be my employees.
Objection. Substantially more prejudicial than probative.
Mr. Long, go ahead.
Your Honor, whether or not Mr. Mehta's employees were current on their certification does not make it more or less likely that my client served alcohol to Ms. Marks when she was obviously intoxicated. It's simply more prejudicial than probative to talk about their certification.
Mr. Staub.
Yes, Your Honor. The evidence I'm bringing that the employees weren't completely certified on those signs of intoxication goes to the knowledge of the defendant, Sonny's Rooftop Bar, the employees that were working there. Because today we're having to prove that the employees knew she was intoxicated or saw the signs of her intoxication. And showing that they weren't completely trained on those signs shows that they're liable in this case.
Mr. Long.
Your Honor, Mr. Staub just said that whether or not they were trained shows whether they're liable. It's not true that whether or not the employees at Sonny's Rooftop Bar were trained determines whether they're liable. What determines whether they're liable is whether they saw Ms. Marks acting obviously intoxicated that night. Therefore, evidence of whether they're certified is more prejudicial than probative.
All right. In terms of the entity's awareness, because we have Mr. Mehta, but we also have the entity defendant, and whether the entity defendant had adequate training, I guess, is my real question is there a duty on behalf of the entity to ensure that the people who serve alcohol are adequately trained? Mr. Long?
Your Honor, while that duty does exist, that's not what's being decided in today's case. What's being decided in today's case is whether or not the employees knew that Ms. Marks was intoxicated when they served her. So whether or not they were current on their certification or whether or not the entity knew that they were current on their certification does not make it more or less likely that she was served when she was obviously intoxicated.
Well, I guess my question was imprecise. Is the duty of the entity or of the defendants to knew or should have known, or is it actual knowledge that's the issue?
Your Honor, the law states that my client can be found liable if they served Ms. Marks when she was obviously intoxicated. So it's to their knowledge, not to what they should have known.
All right. And Mr. Staub, do you agree that that's the state of the law?
We would actually like to disagree, Your Honor. We don't believe that we have to prove that they knew she was intoxicated. We have to prove if a reasonable person should have known that she was intoxicated. And showing that they weren't up to date on their certifications shows that they were in a position that they should have known. And whether or not they were trained is relevant in today's trial.
And does anybody have a jury instruction or a section of the verdict form to which you've agreed that you'd like me to review in order to finish ruling on this objection? I'm sorry for the delay.
Yes, Your Honor. One moment.
The second chair is pulling it up as we speak.
Outstanding.
If you could scroll down to the next page, it says the plaintiff has brought a claim for wrongful death based on violation of section 25602-1 of the California Business and Professions Code. That law provides that a person licensed to sell alcohol under section 23300 of the California Business and Professions Code is liable for any injury or death caused by selling, furnishing, or giving alcohol to an obviously intoxicated minor. Nothing in that statute says whether they should have known. It says whether they knew and whether she was obviously intoxicated.
Your Honor, may I be heard?
Yes.
Your Honor, I'd like to direct your attention to the first portion of jury instruction number 12, specifically where it says, obviously intoxicated means that when defendant served Jessica Marks alcohol, Jessica Marks displayed symptoms that would lead a reasonable person to conclude that she was obviously intoxicated. It omits the fact that we have to prove the defendant knew she was intoxicated, and only says that it would lead a reasonable person, that someone in that position should have known.
All right, thank you. I'm going to overrule the objection as to substantially more prejudicial than probative. If the witness has answered, the answer will stand. If he has not, then Mr. Staub, you can re-ask the question.
Yes, Your Honor. So to clarify for the members of the jury, you didn't verify that your employees had completed that course, yes or no?
I did. I asked every single one of them. Every time that they needed to have a new certification done, I would ask them if they completed it.
Well, Mr. Maiden, let me ask you this. Did you obtain a certificate that they completed that course?
No, as I was going to say before, I made sure I only hired people that I personally trusted. So I was willing to take my employees at their word that they were certified.
All right, Mr. Maida, you told us on direct examination about all the signs of intoxication you're supposed to look for, right?
Yes.
And you realize that if you see someone who's showing obvious signs of intoxication, you're legally required to stop serving them?
Oh yeah, I would do that all the time. There would be people in my bar that were like that maybe once a week, and I would cut them off every time. I'm not trying to get anyone hurt. I'm not trying to get in trouble with the law.
Well, you told us that you've done this with lots of people. I want to talk about whether you did this with Jessica Marks. I noticed on direct examination, you told us 5 times that Miss Marks didn't show any signs of intoxication, completely sober. 5 times. Is that right?
You are somewhat conflating two things there. I would say that there was never a time where she showed one of those symptoms of intoxication, but I wouldn't say she was completely sober the entire night. I mean, I was serving her alcohol. I could tell that she drank. You know, there were times where I would go up to her, you know, whenever I was serving their drinks, and you could tell that she drank, but she wasn't showing any of those symptoms in particular. So I wasn't concerned that she was obviously intoxicated.
Well, let's see if you saw those signs of intoxication. You saw her arrive at your bar at 9 p.m., right?
That's correct.
And you took her drink orders throughout the night.
Yeah.
You visited her table 8 to 10 times.
Yeah. Sounds about right. Something like that.
And you heard Miss Marks when she was speaking, right?
Oh yeah. Every time she ordered, I could hear her.
You could even tell she had an accent.
Oh yeah. She was, I mean, something like Jersey, something like that. She was somewhere from far away from here. I can tell you that.
All right, well, I'd like to take a look at Miss Marks's intoxication. Your Honor, I'm showing what's already in evidence as Exhibit 10. And Your Honor, before we play this video, we'd like to read Stipulation 18 into the record.
Go ahead.
It says, Exhibit 10 was posted to Jessica Marks's Instagram account at 11:11 p.m. on March 24th, 2019.
And so stipulated?
Yes, Your Honor.
Mr. Long, I was asking.
Of course, Your Honor.
So stipulated.
All right, and we'll enter the stipulation, instruct the jury, and Mr. Staub, you can proceed.
All right, let's play the video.
Your Honor, at this time, I'd like
Hi,
to raise a
everyone.
Wait,
cumulative objection to the playing of this video again.
all right, and there's an objection under cumulative, and Mr. Long, why don't I hear from you first?
Yes, Your Honor. This video has already been played during the direct of Morgan Levin. Playing this video again, and this, even in this context, would be substantially more cumulative than it is probative, just presenting evidence that's already been presented again without adding any new facts to the situation.
And Mr. Staub, how are you going to distinguish this playing of the video from the earlier playing of the video for the jury?
Well, Your Honor, when I played the video for Mr. Levin, I asked him if she was acting that way the entire night. That's why it was relevant when he testified. I'm displaying it now to get this witness's opinion on how she was acting in this video. That if he was watching this video, he would have seen the signs and stopped her. Your Honor, I'm specifically asking this witness about his experience with this video after it's been played.
All right,
Your Honor, I'm not sure if the same happened to you, but I was just logged out of the meeting. Is there a way, or are we still talking about Exhibit 10? I believe you're muted, Your Honor.
I guess all of us were kicked out just momentarily, but I unfortunately must have been looking down when we got kicked out. I had overruled the objection. I said, go ahead, but make it quick.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Maida, you can tell that. Sorry about that. Mr. Maida, you can tell that Miss Marks is the woman in that video, right?
Yeah, I recognize her.
And you can see that Miss Marks is in your bar.
Yeah, that'd be table 4 of my bar.
And you can see from this video that Miss Marks could be intoxicated.
Yes, I would say that it is a possibility. If I had seen this video, if I were there when this video was being recorded, I certainly would have kept an eye on Miss Marks for the rest of the night. However, I never saw this video until I've seen it in court now when we're talking about this case.
Just to clarify for the court, Mr. Maida, if you were present, seeing and hearing Miss Marks in this video, you would have thought it was possible she was intoxicated?
I wouldn't have thought she was intoxicated from the video alone, but I would have thought it would have been safe, and that's always how I like to practice, to make sure that she wasn't intoxicated, to check on her for symptoms throughout the rest of the night.
Well, Mr. Maida, to answer my question, you would have thought it was possible she was intoxicated, yes or no?
I guess yes. I'll answer yes. My apologies, I'm not trying to argue with you, sir.
Yes, of course. But Mr. Maida, you never cut off Miss Marks that night, did you?
No, I did not. Once again, I didn't see that video that night, so that that information was never given to me in time.
Well, after this video was taken, you saw her leave your bar at 11:45?
That's correct.
She told you how she'd be getting home.
Yeah, she said that she would be driving, and very fortunately said that Morgan Levin wouldn't be.
Well, when you heard Miss Marks say that she would be driving herself, you didn't stop serving her drinks, did you?
No, I did not.
Your Honor, I believe the time has expired.
And I do have that. And any dispute from plaintiff's second chair?
No, Your Honor, I don't believe so.
All right, then redirect.
No redirect, Your Honor.
All right, and Mr. Mehta, you can step down. Does defense rest?
Yes, Your Honor. At this time, the defense rests its case in chief.
Before we get to closing arguments, everybody okay with about a 5-minute break?
Yes, Your Honor.
Yes, Your Honor.
Anybody need longer than 5 minutes?
No, Your Honor, 5 minutes is perfectly fine.
Outstanding. 5 minutes starting now. All right, we have all counsel, and Mr. Staub, are you ready with your closing argument?
Yes, Your Honor.
And I'll remind everybody to switch to speaker view for closing. Anytime you're ready, sir.
Yes, Your Honor. They didn't even try. I want to take you back, members of the jury, to the direct examination of Sonny Maida, to something he said so confidently. When Mr. Long asked him to list off the signs of intoxication, he listed off almost every single one, almost exactly how they're written in your jury instructions today. You see, the defendants weren't ignorant, that they weren't unprepared, they were just uncaring. Because when they saw those signs of intoxication, they knew what they were meant to do. They knew it was time to cut off Jessica Marks. But they didn't even try. So, as the plaintiff, we've brought a claim of wrongful death against Sonny's bar. We had to prove that while Jessica Marks was a minor, the bartenders saw the signs for intoxication, continued to serve her, and that caused her death. Now, it's undisputed Jessica Marks was a minor. It's undisputed that alcohol caused her death. You saw today how her blood alcohol content was 0.1%. You also heard that they saw the signs of her intoxication. Morgan Levin told you how clearly drunk she was, which makes sense because you saw all the drinks she ordered. wine, beer, shots, 3 hard seltzers. But you don't have to take Morgan Levin's word for it, because you saw for yourselves how Jessica Marks was acting. You saw it in that video. She was slurring her words. She wasn't making sense. She had dropped a can, had trouble picking it back up. She was obviously intoxicated. But Sonny Mehta told you on direct examination 5 separate times that Miss Marks didn't show any signs of intoxication, was completely sober. But facts are tricky things, members of the jury. Because when presented with the facts of that video on cross-examination, Mr. Mehta changed his mind. He told you that in that video, Miss Marks looks intoxicated, that he would be concerned, that he'd want to have a conversation about how much alcohol she was drinking. He saw those signs of intoxication and he just didn't care. Now, the defense will try to say that Mr. Mehta was only around for a few interactions at a time. But when you go back to deliberate, members of the jury, you'll have that video. You'll see the time signature on that video, 37 seconds. Members of the jury, we saw today, you can learn a lot about a person in short interactions, especially if you're trained to see the signs. Which brings me to point number 2 that proves them liable. Even though she was drunk, they didn't stop serving her. Even when she fell down the stairs, even when they said, we might need to cut this one off, they took her order again, brought her another drink, and didn't stop serving her. Now, the defense, they'll try to tell you that it's actually Jessica Marks's fault. She died. That because she chose to drink and drive, that it's her responsibility that's on trial today, not the bar's. But if Sonny's bar stopped serving Miss Marks, she drives home safe. End of story. Case closed. It's why the law exists. You see, drunk people don't make the best decisions. They're impaired. So the point of the law is to have the bar required to stop serving not someone who's fall down drunk. The point of the law is to stop serving someone before they get to a point Jessica Marks was. The law says the bar is responsible, not the 19-year-old kid who was trying to order drinks with her friend. Jessica Marks was 19 years old, had friends and family that cared about her, was still in college, had a whole life ahead of her. And if the bar had done what they were supposed to do, what they were trained to do, what the law required them to do, for all we know, she would have lived that life. But they didn't even try. So for that reason, we ask you to hold Sonny's bar liable for Jessica Marks's death. Thank you.
Thank you, Mr. Staub. Mr. Long.
Yes, Your Honor. Just a moment while I set up. May I proceed?
Yes.
Members of the jury, Mr. Staub just told you that my client knew that Miss Marks was intoxicated and that they didn't even try to stop her. But members of the jury, the employees at Sonny's rooftop bar couldn't stop what they didn't see. Mr. Staub just told you that my client served Miss Marks round after round of drinks. And he's right. My client served Miss Marks those drinks because she ordered them. clearly and coherently. She gave the bartenders no reason to believe that she'd had too much to drink. So they made the reasonable decision to keep serving her. They couldn't stop what they didn't see. Now, today, the plaintiff is accusing Sonny's Rooftop Bar of wrongful death. And when they did that, they incurred a burden, meaning that they have to prove to you that two things are more likely than not. First, that my client served alcohol to Miss Marks when they knew she was intoxicated. And second, that serving was a substantial factor in her death. And today, Mr. Staub just got up before you and told you a lot about how much Miss Marks had to drink, what her BAC was, or how she was acting when the bartenders weren't around. But none of that gets you closer to answering the question that you're here today to decide: what my client knew. Because what her BAC was, how she was acting when the bartenders weren't around, and what she was doing, how many drinks she had, doesn't tell you whether my client knew that she was intoxicated before they served her. They couldn't stop what they didn't see. Now, you may ask yourself, how could someone like Miss Marks have that much to drink and still look fine? Well, today you heard just how that might happen. You heard that Miss Marks had 3 years of drinking experience under her belt before 2019, that she drank every weekend in high school. And when she went to college, it just got worse. You heard Miss Levin say that Miss Marks had also gotten experience at drinking and driving. And that she said she's gotten pretty good at driving after a big night. Now, Mr. Staub told you that drunk people don't make the best decisions. And he's right. When you're impaired, sometimes your judgment can get a little hazy. But Jessica Marks didn't decide to drive when she was drunk. She decided to drive before she even arrived at the bar. She drove there in her car and was planning to take that car home later that night. Which makes you wonder, who's more at fault in this scenario? The bar, who served a seemingly coherent customer the drinks that she asked for, or the one who got in her car that night, knowing full well she was in no condition to drive? No, Mr. Staub has failed to present any evidence that my client knew that Miss Marks was intoxicated when they served her. The only person who told you otherwise was Mr. Levin. But you also heard that Mr. Levin might not be the best person to trust. You heard that Mr. Levin lied to the police about the number of drinks they had that night. Now, they were even lying to you today. Mr. Levin said they only had 3 drinks that night. But both Mr. Mehta and a fellow bar patron told you that they were having a lot more than that. Which makes you wonder who you can trust more. The one who was lying to you about the number of drinks they had? Or the bartender that was stone cold sober that night? Now, the only instance that Mr. Levin could point to was when he claimed that Mr. Mehta saw Ms. Marks stumble on the stairs. But you heard Mr. Mehta say that simply didn't happen, which again makes you wonder if you can trust the one who was lying to you about the number of drinks they had. Now, we're here today to decide what my client knew. And that's why Mr. Mehta got before you and told you what he knew. He told you that Ms. Marks exhibited no signs of intoxication whenever he was around. No bloodshot eyes, no flushed cheeks, no stench of alcohol, no loss of balance, no trouble standing, no poor hand-eye coordination, no slurred speech, no loud talking, nothing to indicate that she'd had too much to drink. Members of the jury, as hard as it is, we have to acknowledge that the only person who could have stopped this tragedy was Ms. Marks. She could have stopped ordering drinks. She could have sobered up. She could have called for a ride home, but she didn't. As for my client, they couldn't stop what they didn't see. Find them not liable.
Thank you, Mr. Long. And then Mr. Staub, any rebuttal?
Yes, Your Honor. Now, the defense just got up here and they told you that their client, Sonny Meda, saw nothing in Miss Marks, no signs of intoxication, completely sober for 3 hours. They told you that they couldn't stop what they didn't see. But members of the jury, what they really want to say is they couldn't stop what they didn't want to see. Because in his closing remarks, Mr. Long actually misquoted the law. He told you that we have to prove that Mr. Meda knew she was intoxicated. But when you go back to deliberate, you'll see all we have to prove is that the employees at that bar should have seen those signs, that a reasonable person should have stopped her when she was intoxicated. And we saw today that when they saw those signs, a reasonable person would have wanted to have a conversation, would have showed some concern, would have tried to help Miss Marks. But when the defendant could have done any one of those things, they didn't even try. And because of that, we ask you to hold Sonny's bar liable. Thank you.
All right. Thank you both very much. So we'll wait until we have all ballots submitted. Let me pull up the chat and see when the other scores let me know that that's happened.
All right, I just received word from Tab that all the ballots have been submitted.
Outstanding. So great job to everyone. This was a joy to watch. I want to keep everybody here not for any longer than I have to. So I'll let our scoring jurors introduce themselves and make some comments. And why don't we go alphabetically by last name, and we'll start with Lindsay Cloud.
Hello. Nicely done, both of you. Excellent job. That was a great round. I have been coaching mock trial at the law school level now for approximately 10 years and participated in mock trial and law school myself. I'm an attorney in the Washington, D.C. area. So I know well how difficult what you've just done is, and I really appreciate the hard work that you both did. I thought you did very well. I'll just make one comment for each of you, just something hopefully that you can take with you and improve upon. On the plaintiff side, Mr. Staub, I thought that we could use a lot more of the human story and the narrative in your opening. I wanted to know what happened. Just I'm in a complete factual vacuum here. I don't know who these people are or what happened to whom. And I really wanted more of that from you. I didn't know how the victim died here. Or really, I was just kind of left wanting too much of the human story at the end of your opening. You have an excellent speaking voice, great connection with the jury. You really did a great job. Just work on that narrative, work on really telling us in a very personable and human way, kind of what's going on here. On the defense side, Mr. Long, I loved your demonstrative. I thought your demonstrative was very clear and very helpful. This is a little pet peeve of mine, so it's going to seem like a nitpicky thing. I don't love referring to your client as my client. And the reason is it's just a little reminder to me, a subtle reminder that you have an interest in the outcome of this. Personalizing your client by calling them their name, Sonny's or whatever their name is, can be a really helpful way to get the jury to invest in them as a person, as a small, it's a small business, however you want to say it, that's going to really endear me to your client. That's usually helpful. Both of you, I think, need a better understanding of the statute that you're working with and the standard. That's just something you want to internalize a bit more so you can be very clear what it is you have to prove and not prove. That's all. Excellent job. Yeah, great job.
And Mr. Mauser.
Hi, everyone. I'm a senior at Franklin and Marshall College. I'm an undergrad mock trial competitor. First, great job to both of you. That was painfully difficult to fill out that ballot. I really wanted both of you to win. Really, yeah, that's especially, no words on that. Just great job to both of you. I'll add on to what Lindsay said by adding, I think, just some small suggestions for improvement, because I think a lot of the deciding who gets the check mark came down to really small things. I would try to work more on tech with both sides, very small things like defense. When you would get up for speeches and examinations, I would think maybe while the other person's doing their thing, you can set up the camera and then just be able to go right in faster. Plaintiff, I don't know if you can still add demonstrators or anything. But also playing the video twice, I didn't think was super effective because that's a full minute of you not talking or crossing or anything. It was just us watching the same video. Really, I think the trial game came down to a lot of small things like that. Really great moments on both sides, and yeah, great job best of luck in the future rounds.
My name's Jack Lucky. I am a newly retired judge from the Riverside Superior Court. I literally retired, what's today? The 24th, I retired 3 days ago. And I've been doing mock trial since 1985. I love this round. And the one thing that I'm going to say to both competitors, I don't know how the ballots are going to turn out. If you've done Gladiator before, and I don't know that you have, the ballots are brutal because you don't get a 9 and a 10, so you're 1 point apart. Right? If one of you scored all 9s and one of you scored all 10s, that's a 7-0 ballot, right? And you feel like you got stomped. And why I'm saying this is because I could see this round going either way. I could see the other scorers disagreeing with me on who they thought edged, because I think that was it. It was the little things as the other said. So the first thing that I'm going to say is no matter what the ballots turn out numerically, this was a really close round, and both of you should know that. For me, the judge side of me comes out, and I will say a couple of little things. Mr. Long, I thought you argued a little bit in your opening, and you made a promise that you didn't keep. You said, Judge, we're going to use this to show knowledge. We're not going to use it to show conduct and conformity. And then when it came to your closing argument, You argued conduct and conformity and you didn't argue knowledge. And I felt kind of like, boy, that was not the argument that you promised that you were going to make to the jury at the time that I made the evidentiary ruling. It's really important that you keep that internally consistent. And I'm going to echo a little bit about what Ms. Cloud said, and that to plaintiff, I didn't feel like somebody died. You know, at the end of this case, I got to feel like somebody died. A 19-year-old girl died, and they didn't care. And your theme said that, and I thought that you marshaled the evidence really nicely, but I didn't feel like anybody died at the end of this case. And I really wanted to feel that, even though it's mock. And so that's something that I think that would have been nice to feel at the end. But great job. We're ending a little bit late, and I don't like to end late, so I'm going to let you all go and prepare for your next rounds. Great job, everybody.
Thank you.
Nice job.
Thank you.